Just imagine this for a second. A massive, statewide energy policy, something that was built over months and months with a lot of public input, is suddenly just flipped on its head. And all of it done in complete secrecy. Well, that is exactly what happened in Maharashtra, and it led to a huge legal battle. So let's dive into how this power play actually unfolded.
So here's the big question, right? What went so wrong that the Bombay High Court had to step in and completely throw out these new, secretly made rules? It's really a story about process, about power, and honestly, about a fundamental principle of fairness.
And this quote, this gets right to the heart of the matter. In the court's own words, the entire secret order was found to be in breach of the principles of natural justice. Now, in simple terms, that just means it was fundamentally unfair. Why? Because the very people it affected the most were never even given a chance to be heard.
Okay, so to really get what the court decided, we first need to look at how this process is supposed to work. It's all built on two key things: transparency and public participation. So, have a look at this timeline. This shows a very careful months-long process. It starts with the state electricity company, MSCDL, filing its big multi-year tariff petition. Then, public notices go out across the state, inviting everyone to raise their objections. After that, public hearings were held everywhere. This is where everyone, from consumer groups to industry leaders, could actually voice their opinions. And only after all of that was the final order passed on March 28th. This is how it should be done.
But then, everything changed. That carefully crafted, publicly debated order was completely undone, and it was done with just shocking speed and secrecy.
Just look at the contrast here. The original order comes out on March 28th. Then, believe it or not, just 3 days later, on April 2nd, MSDCL gets its stayed. Its implementation is completely stopped, with absolutely zero public consultation. For the next 3 months, while all the stakeholders were trying to intervene, the regulator worked completely in private, only hearing from MSDCL. And then finally, on June 25th, they just dropped a brand new review order without holding a single public hearing.
So what did the secret order actually change? Well, for solar energy producers, the time they had to use their banked electricity was slashed from 17 hours a day down to just 8. For the entire hotel industry, electricity rates were hiked by reclassifying them from the lower industrial tariff to the much higher commercial one. And most shockingly, the approved capital spending for the electricity company more than doubled. It jumped from about 31,000 crores to over 87,000 crores. And that's a massive cost that would eventually be passed on to every single consumer in the state.
Now, with such drastic changes hitting so many different sectors, a fight was inevitable. This wasn't just some minor tweak. This was a fundamental shift in policy, and it was all done behind closed doors.
And this wasn't just one or two unhappy companies. No, a massive, diverse coalition from all across Maharashtra's economy decided that this was completely unacceptable, and they took the regulator to the High Court.
And just look at who stood up against this. We're talking about renewable energy companies whose entire business models were threatened. We have the Steel Producers Association, major data centers like Control-S and NTT, cement giants like Ultratech, the entire hotel industry, and a whole host of industry associations representing countless businesses. It was a completely united front against a process they all saw as illegal.
So, the battle lines were drawn, setting the stage for a major legal showdown. All eyes were on the Bombay High Court to see how it would rule on what seemed like a clear violation of public trust.
Now get this. The regulator claimed this new order was just a review, implying maybe some small corrections. But this so-called review order was a massive 86 pages long. That's hardly a simple fix, right?
And the court saw right through this argument. They pointed out that an 86-page document, especially when the original was 95 pages, isn't for fixing a clerical or arithmetical mistake. This was a complete and total rewrite of the original policy, a substantive overhaul done without any public input at all.
And this brings us back to that core legal idea, the principles of natural justice. At its heart, it's actually very simple. It means you have a fundamental right to be heard before a decision is made that negatively impacts you. It's the right to tell your side of the story. And the court found this fundamental right was completely and utterly ignored.
So the court's findings were crystal clear. The regulator broke its own mandatory rules. The verdict was simple but powerful. You cannot create a policy with public consultation and then secretly turn around and change it without that same public consultation.
The court held that the whole process violated the clear mandate for transparency that's written directly into India's Electricity Act.
So, the final outcome? The secret 86-page review order was completely quashed and set aside. It was totally wiped from the books, and the original order, the one created through the proper public process, was immediately reinstated. It was a total victory for the petitioners.
You know, this case is about so much more than just electricity tariffs in one state. It raises a crucial question for all of us. This ruling strongly reaffirms that public participation isn't just a suggestion, it is a mandatory legal requirement. It sends a powerful message that policy cannot be made in secret. So the question we're left with is this. In an age of fast-paced decision-making, how do we make sure the public's voice isn't just heard, but is truly powerful?